thank all of you coming. We're going to be considering the bill as well as any amendments to the bill. We had several members bring forth thoughts about items of the bill that may be amended. We're going to address these. I do not have a specific order, but I'm going to try to put some order to it. I've got a list of what is 7 various topics that were raised at the meeting yesterday, and yes, you have another one? Time's closed. No, what's your other one, Mr. Tomlin?
I'd like to make a motion that we go back to the original Senate Bill 383.
Okay. I think what you talk about may be resolved by several of the amendments that we're looking at and some other steps as part of that process. Let me do this suggesting wise. Let's talk about the issue of the definition of day, and that is your proposal, Representative Tumlin. And do you have a proposed bill amendment that addresses that, or do you want to talk about based upon what we had under the old bill of 382 that came to the Senate?
The motion I'd like to make that here for the definition as defined in 2065.
Let me get down to that section. $2,065. Let me get you to state your amendment and speak as to the amendment. Yes, sir. There's a sheet, should be in your folder, resembles this. Now, the bill that we're working off of, so everybody's aware, the one in your file, the LC number is 292402S. That is the largest staple document you have in your file. That is the bill that we had Legislative Council prepare based upon what we call the tweaking amendments that came in from the Commission and was presented to us by Ms. Travis. Correct. Correct. That's right. Well, the other change she suggested dealt more with a policy issue about what is the items that would be included with the calculation for income, self-employed income. All right. Everybody has a large bill. Are you ready, Mr. Tomlin, to talk about your amendment?
Yes, what I'm proposing is that we take section 1, paragraph D, period of time adjustment, take 2065 first in its entirety, and delete section G on page 18 of 2402S.
Now, your amendment is, I'm looking at this sheet, 2065G, parenting time adjustment, would go from line, what is 21 to 35. Is that right? Down through 30. You see that on your copy? This is what I'm looking at.
That was a very, very
Yes, sir. Isn't that what you're talking about? I have that. It's missing a page. All right, hold on a second. Ms. Travis, what is the one that, first of all, that we have that would be the language as it came in from the filing before the Senate? Do you know?
The number is the original version.
All right. Would you say there's a page missing out of this?
Just on mine, apparently.
All right.
No, there's one missing on mine as well. I go from 18 to 20. That goes from 18
Yeah.
to 20.
We didn't have the back. Mine doesn't have a back. All right. Some have back, some don't have back. Does everyone have one now with what we'll call the printing of pages 18, 19, and 20? Do you have another one printed? There you go.
We need another one.
Does everyone have one in hand now, or read with your fellow committee member? All right. Everybody ready? Ms. Oliver.
As I understand it, what Mr. Tubble's intent is to return to the money that the
I think we're talking. All right.
What, the chief of the commission, it was reduced.
All right. What I'm looking, excuse me, I'm sorry. Go ahead, Ms. Oliver.
Just procedurally, does Mr. Lindsay intend to offer his amendment that we discussed yesterday?
And that's what I'm getting to. I think what I wanted to deal with from the discussion, I remembered, Mr. Tumman, was the going from the change of the 12-hour to what we call the calendar day definition under this section, G, but not get into what the numbers of days will be as a part of the same section. Does that clarify what I'm concerned about?
Yeah, I think what I was proposing, you put in G, and put in the original number of period of time units, and then if we chose to amend that. So I think these period of time units go with overnight.
I know, but
Day.
let me ask, to what you're proposing to do, Representative Lindsay, that will conflict what I'm seeing under Section 3B.
Yeah.
We have the days set out by percentages, correct?
Yes.
So I'm asking if we want to, at some stage, really get to the definition part in talking about an amendment, what is to be the intent of the definition of a calendar day?
And I could amend my proposed amendment to go. And I'm thinking the one where it's just G1 where it defines the
G1, A, B, C, and D paragraphs, and then 2 starts out the child support obligation table based upon expenditures, child, etc. All right. And you're going to be substituting that for what portion of the bill as we currently have it before us?
G1, the paragraphs A, B, C, and D, in lieu of just G1.
So, and this, does everyone understand? Ms. Travis? Let's go to the bill. Paragraph 1, which is under the bill as before us, G on page 18, paragraph 1. I think the proposal is that be deleted and in its place substitute on the draft of 292065, page 18, paragraph G through the bottom of the page, which is 1, A, B, C, and D. There will be other amendments, what I'm looking at. There will be other amendments dealing with the dates. And then go from there, through that source, as opposed to putting it in place. All right. Yes, ma'am.
I'm trying to get the procedure here in my mind, and I'm confused.
Are we all?
If Mr. Lindsay intends to offer his amendment, and then I have an amendment to his amendment, I'm trying to think through a way that would make this most logical. Does Mr. Lindsay intend to offer his amendment?
Yes.
He does.
Okay. And if I remember correctly, your amendment gave a change of percentage based on the number of days up to 180.
Yes.
That's the amendment you're going to offer.
Yes.
Procedure, what I'm suggesting we're doing from what the conversation we just had with Ms. Travis, is if this is passed, we'll have this passed as an acceptance of a replacement in the bill of the entire section dealing with parenting time adjustment. G.
I think
Then we'll say, then what we'll do, once that's accepted, if it's accepted, then we'll go through the other proposal as to whatever changes be made in G as now in the bill.
And the purpose of Mr. Tumlin's amendment is to define the days, basically. Not the number of days, but define what a day is.
That's part of it, yes.
Okay.
And I'm saying there are the things Ms. Travis suggests is, well, let's replace the whole thing and then start from there as being the language to be changed, if anything, out of G, once it's put back in. Is that correct? Does everyone understand the proposed amendment, first of all? Any questions about it?
If I understand correctly, this amendment, if adopted, will simply take us back to the bill as it was originally offered by Senator Hart in Judiciary, Senate Judiciary Committee, both in terms of the parenting time units and in terms of the percentage changes and the dates.
Correct. And then from there, once that's in the bill, if there's anything to be done as far as offering amendments to that portion, we can work off this bill, this change. You follow me? Okay. Discussion on the amendment. You want to state your amendment first, so be sure we got it straight, Mr. Tomlin?
That's right. I move that we delete D1 in 2402F on page 18, being lines 5 through 12. And in lieu of, replace with G1 with subparagraphs A, B, C, and D, which on the original was lines 5 through 19 on page 18.
All right, I won't accept that emotion. That's contrary to what we're talking about doing. We're talking about taking all of what is section G all the way through,
Okay.
which goes over through on this draft copy 2065, all of page 1, all of page 2, and the top of page, I'll say 3, it's actually numbered 18, 19, and 20, top of page 20 through line 7.
I misinterpreted, and I prefer that too. My motion would be to take G out, as you just stated, and replace with the G under the original bill in 2061 in its entirety.
Does everyone understand Mr. Tomlin's motion? All of G is being amended based upon the draft of Senate Bill 382, copy number LC 292065. Discussion on the amendment.
No, I got a discussion.
Yes,
So
ma'am, Ms. Thomas.
Basically, Mr. Tomlin, this, by changing this language, what's the effect? What's the effect of what you just did? If I may know.
Probably the most dramatic, the one thing, this was the work of the committee. And I think they worked hard, and I think it was a lot of various sources, the judges and all. And I think one very clear difference is in the one I'm asking to be replaced, a day is defined as 12 hours in a calendar day. This also is a little bit more expansive. That includes an overnight as qualifies for a day. And I think what the Senate had the problem with, some weekends would be 3 days, but I think the committee that studied, the commission that studied this summer contemplated that when they built their formula into the parenting times unit.
So does the effect of it have reduce the amount of time that's needed for? Does it reduce the amount of days? Is it what's the present is it 120? So does it reduce the amount of days in terms of that would seem to be a reduction in the amount of days that the non-custodial parent would spend with the kid at the same time they would still get the benefit of the adjustment?
Yes, the one I'm proposing we change, I think, maybe understates it to a degree, and this, in certain cases, like the weekend, could overstate it to a degree. But it's including the parent time units.
Anything further?
That's fine.
All right. Other questions? Other discussion? On the amendment?
If I may, Mr. Chairman, if I, pardon me, inquire here, if we wanted to get to my proposal, which would be to maintain the Senate language regarding parenting time, but go to a grid system of 91 to 180 days with incremental increases, we would need to vote down this amendment and then go to my separate amendment dealing with how I would do the grid. Is that correct?
If you're saying your grid would not work with what the proposed amendment is, that was your point?
Yes. If I wanted to maintain parenting time in terms of how the language is in the Senate, from the Senate, but wanted to go to my grid system, we would need to vote down this amendment and then go to a separate proposed amendment. Correct?
Correct.
Okay.
Any further discussion on the amendment? We're ready to vote on the amendment. All in favor of the amendment, raise your right hand. Count 4, 5. Excuse me. See, let's do it together. 1, 2, 3, 4, 5. In favor, opposed. 1, 2, 3, 4 opposed. The amendment carries. Next amendment. State your inquiry.
Is this, resolving Mr. Lincoln not related?
Amen. That's not the intent. Where we're going next is going to be discussion now of Mr. Lincoln. Pardon? We're getting ready to discuss the next amendment with you, Mr. Lincoln. Mr. Lindsay has an amendment which is AM 290502. It should be in your documents.
Parliamentary inquiry, Mr. Chairman, because I want to make sure. It had been my original intention to have a amendment that would have preserved that part of the parenting time adjustment to maintain the original, rather the language from the Senate regarding the definition of a day, and then add to it this grid. I want to know whether or not that would be in order given the vote we just had accepting the parenting time units.
I would suggest that would not be in order
Okay.
for that portion of it.
All right, in which case,
If you're going with this one, this is what your amendment is.
yes, sir,
That you're proposing. It doesn't cover that
that part.
section of the language, so it would not be in order.
That would not be in order, in which case, Mr. Chairman, it's a fallback amendment to what has already been passed by this committee, I would offer the amendment that from AM 290550.
You're not asking them for the consideration of the first amendment, 0502.
Well, I think, given your ruling that it would be out of order, given the vote, my original amendment would be out of order, given your ruling.
My statement and ruling as far as being out of order is out of order as to the change of that provision. That's why I asked you earlier.
That's what I'm
This
saying.
one, I asked you earlier if you wanted to consider this. You said no, it didn't have parts of that that you wanted to be included. And that's why I put it aside, and we're not going to consider that.
I hear you.
So if you want to consider your next amendment, then we're back to 0502. We're not going to re-amend what's already been amended. It's part of the language.
No, Mr. Matthew. That was the reason for my question, Mr. Chairman.
You may want to have a motion to reconsider to bring back what would be the previous amendments before you get to that. I think you should better state what you were trying to do with this as opposed to leave it open to the question of having that other amendment without knowing what the effect it would have if this is brought up in the matrix system.
Well, that was the reason for my original parliamentary inquiry as to, and therefore I do move to reconsider the previous vote. My intention would be to go with a matrix system, but with the parenting time definition contained in the Senate bill as passed by the Senate. That was my original intention for my proposal.
Parenting time definition.
For the parenting time definition as adopted by the Senate.
Just so that people know what I'm about to do. The chair wishes to help me, I'm going to do this in a way that's most procedure and appropriate. I want to amend, offer a substitute amendment to Mr. Lindsay's amendment, which deletes the entire parenting time amendment, paragraph G, to 6, in lieu thereof, prohibiting parenting time amendment with the following language: the court or the jury may deviate from the presumption of child support and consideration of care, physical custody arrangements, including the same against family. Mr. Lindsay told me that Mr. Lindsay's amendment is offered, I'm going to offer this substitute, which I think would clarify all the procedural inconsistencies. This would be the new parenting time amendment. New paragraph G that's put in some. Also the new paragraph.
The new paragraph G, which you're calling under here,
Parenting time amendment.
this would be the extent of your paragraph G.
Yes, sir.
What we have done, here's where we are again, back to procedure. We had a motion made. Mr. Thomas' motion to amend was the entire section of G. If there was going to be a change of that proposal at that time, it should have made it, the issue being raised, question as to this paragraph G. Once that was adopted, that's past the point of amendment.
Well, that means that Mr. Lindsay's class is
Well,
part of amendment too.
And that's where getting back to this reconsideration, I was going to his based upon the matrix system that he wanted to put into it. But you wanted to take out the entire section.
Yes, sir.
Now, his amendment would be to do this. Your amendment would be to delete the entire section.
Yes, sir. And in fact, the
Subject
only, the
is-
fact that paragraph G has been amended irritates the position that no longer paragraph G limits from the active.
I'm taking the position, once you get through with paragraph G, yours is delete the entire thing. His is now amended in portion of what was accepted.
Yes, sir.
But he can't do it.
I want to delete paragraph G entirely. I think what I'm asking to do is, and I'm
amendment that was accepted, 6-5 vote, Mr. Tumman, which was to substitute paragraph G on the copy 2402. There we'll start dealing with 24G, not in part pieces. There's a whole section. So we'll accept the amendment. Okay. We're going to have to go through the reconsideration of your back up. Is there a motion to reconsider? Any discussion on the motion to reconsider, which is the amendment put forth by Mr. Thomas? All in favor of the amendment, say aye. Aye. Opposed? Aye. Raise hands. All in favor of the amendment, signify by raising your hand.
Motion.
Motion to reconsider. That's all we're doing. Bring it back to where we were before. The common amendment. Motion to reconsider. Raise your right hand. 1, 2, 3, 4. Opposed? 1, 2, 3, 4. Chair will vote to reconsider. Now, back to the Tomlin amendment. Tomlin's amendment is the language we have using the document identified as LC 292065. Everybody understands the bill, the amendment for. Comes amendment. Motion made for substitute, take the substitute. Further discussion. Ready to consider the motion. The motion to amend is language is stated. Read it again.
I am leaving line 5, paragraph G, where heading parents and family rescue on page 18, inserting in lieu of line 6 on 18 through line 20 on page 19, the following line. The court or the jury may deviate from the presumptive amount of child support in consideration of shared custody arrangements, including extended visitation.
Everybody understand the motion? All
Yeah,
in
but,
favor?
but this, but, excuse me,
Thomas?
but by doing that, you believe this, helps the situation? Okay.
Any further discussion on the motion? All in favor of the motion, signify by saying aye. Opposed, like sign?
Aye.
Ayes have it, I believe, that's all.
Call for
Go
division.
ahead, Ayes have it.
Call for division.
Call for division. All in favor of the motion, signify by raising your right hand. 1, 2, 3, 4, 5. Those opposed, like sign. 1, 2, 3, 4, 5. The chair votes no. Motion is defeated.
Mr. Chairman, I have a motion.
Next, we have still the motion before us is on the common motion. Any amendments to this motion?
Yes, Mr. Chairman, I have two. My first amendment, Mr. Chairman, would be to substitute for his amendment. It will take, the committee will follow me for a moment and pull out AM 290502. first off, Mr. Chairman, and also if the committee will go to page 18 of LC 292402S. And my amendment, Mr. Chairman, would involve reinserting the language from G1, 2, and 3A, with the exception of striking on line 19 the number 120 and inserting 90 days, and also then beginning at B, insert AM 290502. What that would do, Mr. Chairman, is that would preserve from the Senate version the definition of a day to be 12 or more hours. It would do away with the present problem in which you would have a standard weekend of Friday from 6 to Sunday of 6 to suddenly be 3 days instead of 2. That's number one. And number two, what it will do, Mr. Chairman, is that it will allow for an incremental increase in the parenting time adjustment by day, rather than the cliff effect that we are facing right now, which will be approximately, as shown by the grid, 0.3% per day. It preserves the basic percentages that were set forth in the Senate version, meaning at 120 days you'll be at 10%, and 137 days you'll be at 20%, etc. But it does it day by day rather than doing it in lump figures as we have right now in the bill, that in effect create the cliff effect that Judge Abbott testified to in terms of the problems with that, as have been seen in other states.
Anyone have any questions of the runner of the amendment? We'll briefly go back through and state your name so everybody understands.
All right. If you would, sort of follow me once again using LC 292402S. Main bill. Look at section G. What it would do is it would reinstate, it preserves G1, G2, and G3A, except for at line 19, instead of 120, it'll strike through that, it'll be 90. And then it would go to the grid system that I have, that is included in AM 290502.
That takes in, beginning with line 22.
Yes, sir.
Section B, and only section B.
Yes, sir.
The remainder of the amendment. Go back, and this is where it gets a little confusing. So I'm trying to use what we have as a current bill.
Yes, sir.
You're not wanting to change.
I do not want to change G1, 2, and 3A, except as where I've noted, striking 120 and inserting 90.
What we have before us as an amendment right now is Mr. Clemens' proposed amendment.
What I would do with his amendment is strike it in its entirety and insert in lieu thereof the language found in 292402S.
Let me state what I'm saying. I'm going to rule your first amendment out of order. You're going to amend the amendment. You're going to have to state exactly what you're going to be changing of 2065. You're picking up language you wanted to leave as a part of the original bill, and that's not what we're trying to do. We're working off the amendment.
I understand, Mr. Chairman. What I want to do is, in my amendment, I would, first off, taking from LC 292065, I would strike everything from lines 22 through page 20, line 7, which is all of G, and insert in lieu thereof the language found in LC 292402S, beginning at line 6 through line 21, with the exception of line 19, in which I would strike the number 120 and put in 90. And then you with me?
You misstate your amendment again, but you stopped at line 6 on the 2065. And that 90 days was on that page with 3A on page 7. Are you taking in paragraph 3A or not? What is your amendment going to say?
Operating off of 2065, Mr. Chairman, I would strike everything from line 22 on page 18 through line 7 on page 20, which is all of G, and insert in lieu thereof, utilizing 292402S, I would insert everything from line 6 on page 18, everything from page 6, line 6 to line 21, with the exception of on line 19, in which I would strike the number 120 and insert the number 90. And then I would insert, Mr. Chairman, my proposed AM 290502. Okay, I'm sorry.
2065, page 19, you talk about going through line 7. Then when you state the rest of your amendment,
No.
you pick up all the paragraph. You didn't pick up all paragraph 3, you turned down to line 21.
Actually, Mr. Chairman, I was going through page 20, not page 19. I was striking everything from page 18, line 22, through page 20, line 7, which would strike.
That's right, that's what I said. 20. Oh, that's it. But you're going down to a line 3A.
Yes, sir. Yes, sir.
Paragraph. I'm sorry.
Yes, sir.
Do line 7. Okay, which is begin just before the beginning of paragraph
H. Basically, it strikes all of section G and inserts in lieu thereof line 6 going to LC 292402S. Inserts everything from line 6 through line 21, except for line 19, where I would strike 120 days and insert 90 days. And then my motion would pick up at B, AM 290502.
Is that the full statement of your amendment?
Yes, sir.
Point of clarification, that you're saying your amendment and the provision as it would stand if amended by your proposed amendment would not require the inclusion of paragraphs C, D, E, of Part B, or paragraph 4 and 5 as shown on pages 18 and 19 of 2402F.
Yes.
Those would also be amended.
Yes, sir. Like I said,
Does everyone understand the motion? Going to be restated. Not restated. Okay, everybody understand it? Want to discuss your motion?
yes, Mr. Chairman. My goal through this motion is to do two things. Number one is to allow for the definition of a day in terms of the deviation from it for parenting time adjustments to be what generally I think most people would regard to be a day, which would be 12 or more hours, and would work well with what most people would regard in terms of blocks of time. The example I gave a moment ago was simply this, is that underneath my amendment, for instance, a weekend visitation from Friday at 6 p.m. till Sunday at 6 p.m. would be 2 days. as opposed to the proposal of Mr. Tumlin, and in what was originally in S 382 would be that same time period would be 3 parenting time units, which is something I don't think most people would comprehend in terms of the logic. So I think it makes more logical sense to go my way. It also, I think, fits within more of a reality as to the relative time and expense that a parent is being spent on a child, in terms of making sure that if there is going to be a reduction in child support, it be the result of actual time being spent with the child by the person. So I think that those two have an advantage. The overnight stay is problematic, I agree, but in a regular overnight stay, let's just say you had a Wednesday night overnight stay, the custodial parent would still be in charge of the child for about 18 hours on both the day in which that overnight began and the day in which that child was returned to school, for instance. And yet the custodial parent would not be given credit for that. So I think that's problematic. I think, like I said, by contrast, mine, I think, fits within what people would normally consider to be a shift in terms of visitation, and when a parent should be given actual credit for that in terms of any kind of reduction in child support. The grid that I have proposed to you also does several things. Number one, it preserves the percentages that are contained in the Senate bill in terms of when there's a 10% reduction. You have, in both mine and in the Senate bill, you have a 10% reduction at 120 days. However, what I've done is I've spread that out, both leading up to that time period and from that time period forward, up to 180, so that there won't be any kind of cliff effect, meaning that 119 there's no, for instance, whether at 89 days there's no reduction, and suddenly at 90 days there's a 10% reduction. I worry about that. Instead, I have an incremental change by day, and I think that would do a lot better in terms of avoiding the cliff effect that Judge Abbott so eloquently spoke on when she appeared before us. So those are basically what my amendments are. If the overnight stay is more than 12 hours in any given day, yes.
Further discussion among the committee? Now inquire something.
Yes, sir.
Does your grid proposal work irrespective of whichever definition we have of day?
I do, Mr. Chairman, have a second amendment that I will propose if this one fails.
Yes, sir.
Well, the answer is it's going to be up to the person who wants to go back to court and try to prove otherwise. That's how you're going to do it. And basically, it's going to be something that's going to be worked out by the judge. I mean, at the onset. I think that in any divorce case, it's oftentimes messy, and you have a lot of similar situations with that. And if the parents start to get into a finger pointing, you're right. There's going to be an awful lot of micromanagement. And hopefully, what it'll do is encourage the parents not to go that far.
Further questions? Questions been called. The amendment was stated by Mr. Wilson. Everybody understand the amendment? Ready to vote. All in favor of the amendment as stated by Mr. Lindsay, which is amendment to the amendment, signify by raising your right hand. 1, 2, 3, 4, 5, 6. Opposed? Like sign. 1, 2, 3, 4, 5, 6. The chair votes no. Next amendment.
Mr. Chairman, I would have a second amendment that's a little bit easier to follow. That's simply AM 290550, which would be a that's basically it accepts the alterations set forth by Mr. Tumlin in terms of G1 and G2 and G3A, but inserts in lieu of his 3B the grid that I spoke of earlier.
All right, let's be sure we understand. We're back on, we're still talking about Mr. Tumlin's amendment came from 292065. Ms. Tumlin, if I understand correctly, your 2065 has identical language as under 0550, beginning with line 7, down through line 10 of page 19. Correct?
Yes, sir.
That is as you stated your motion, Mr. Lindsay?
Yeah, basically it would yes, Mr. Chairman.
Then from there, we pick up with 0550 as to line 31, page 1, through the end of the page 5.
Yes, Mr. Chairman.
Does everyone understand? Ms. Travis? So will the proper motion be to have a substitute on Mr. Amendment to the amendment, which is substitute 0550 to what is 2065? Thank you. Would you like to make your motion in that manner?
Yes, sir.
State your motion.
Make sure I got it.
The statement is a substitute motion. Mr. Lindsay, I understand
Yes, sir.
you want to make a substitute.
It's a substitute.
Motion.
It's a substitute motion to Mr. Tumlin's motion, in which we would insert in lieu of his amendment, we would insert instead AM 290550.
We're dealing strictly with this, which would be a replacement of the amendment proposed and initially adopted on the table for reconsideration by Mr. Thomas. Does everyone understand the motion? In fact, what we'll be doing is adopting for section G, 0550, which has, as I understand it, the original language as brought in from the commission on the parenting time, overnight, the parenting time definitions, and then using effectively what is your grid schedules for increasing time from 90 days forward.
Yes.
That's distinctly stated?
Yes.
Okay. Does everyone understand the motion? Any questions of the motion? Yes, sir, Mr. Thomas.
My comment, just the only thing that's really being changed is 3B.
That's
Yeah,
it. That's
everything
fine.
else is substantially the same language.
Yes.
Okay. Everybody understand? Are you ready to vote? Call the question. All in favor of the motion, raise your right hand. All opposed, like sign, the motion carries. So we have substituted section G by 290550. Ms. Oliver, that takes care of the issue you had about parenting time, correct? So we adopted this, and your motion is briefly take the floor there and sort of feet there, correct?
Yes, but I'd like to look at consideration.
Didn't mean to stir you up.
I'm just trying to figure out who cops are in the room right now.
This might have been in the bill committee when you were saying when the Judiciary committee, just like
He's an ex officio member.
you didn't complain
He
then.
was in the rules, an ex officio member of this committee.
Be consistent. Be consistent.
Out of order. Out of order. Come on. Back to the issues at hand. I'm gonna have to rule your motion for reconsideration out of order because it was not made after completion of the completed motion, so. Wow. I just wanted to go over my list again. The next one we have is a provision, a suggestion by Representative Crawford as to having the provisions of this bill applied prospectively. Get it through to eight, get it around everybody. File a modification. There was some of the final orders and cases file a modification. Like you file a modification with that apply only for those actions that are filed after. Explain further what effect the amendment would have existing orders of child support as they are now in place, may have been for several years. So,
wasn't agreed about contract that wasn't in place at the time that those contracts, those settlement agreements were entered into.
yes, sir. Yes.
Well, I don't know about that. I mean, and I'm serious when I tell you that.
If I may, Mr. Chairman, nothing in this provision bars you from being able to bring a modification based on any kind of economic circumstances. You could before, you could after. The only thing it does do is it bars you from, when you played by the rules before July 30th, based on what the rules were on child support, you can't simply
bring a request for modification based on the new law. On that basis alone. You can still bring a modification for all the other reasons that folks can bring modifications, either a change in income upwards, a change in income downward, lost job, etc. None of that changes. The only thing that this proposal will do is keep someone from simply bringing a request for modification solely because the method for calculating has changed.
By parenting time.
By parenting.
Oh, excuse me. Let me get Mr. Hatfield. You want to go ahead and follow up on that same, Mr. Hatfield?
Mr. Chairman, the point I would like to make, I do believe there's some constitutional problems with the bill or with the amendment. You know, we've got a right to access to the courts. You've got a right to have people that are similarly situated treated similarly. And this amendment would treat similarly situated people differently based solely on the circumstance of when a decree was entered. And I suggest that we would find that not only would this be unconstitutional, but it would create a real fiasco for lawyers, judges, and parties in being able to determine what law was applicable in any given situation. I suggest that this is not a good idea, and I would certainly urge the committee to reject that proposal.
Mr. Crawford.
You don't come back and modify toward judgment.
Have to apply, because when you may have entered into an agreement, especially in child support was part of that agreement, when you gave up property, when you sat down and either went through mediation or a judge made a determination on child support, it was made, and part of the consideration was more than just child support. It was not strictly child support. It was awards of property, all sorts of things that took place, and taking on debt and other matters. Somebody may have taken on more debt to pay less child support. I mean, I think you're changing the rules in the middle of the stream.
All right, I'm gonna ask everybody to keep a brief statements of Mr.
I'm sorry, Mr. Chairman.
O'Neill. No problem. I got something I want to bring to everybody's attention in a minute. Mr. O'Neill. Yes.
If we voted yes for this, this would in no way, shape, or form contemplate parenting time. Right?
No, I'm not trying. That's right.
You're trying. So the policy of parenting time we have in the major bill for everybody that's been divorced before July of this year, that's not going to apply to them now.
That's exactly right. That's the biggest thing.
That's what you're trying to do.
Yes, sir. That's what we're trying to do.
Ms. Oliver.
We already have in the statute, based on 19619, modification of alimony after July 1st, 1977. And that was not declared unconstitutional. We had a change of the rules about alimony that specifically, if you read the code, it goes through actions before 77, actions after 77. I think that we're weighing, in relation to this amendment, we're weighing two sets of catastrophes. I think that was your word, catastrophe, about if we pass this. Well, the other catastrophe, whatever word you use, it was kind of a big word. I'm weighing which is worse, the catastrophe or the bad results of extra litigation under the current statute versus an argument that will be made for these two different groups of people. Which is worse? And I suggest to you specifically that we already have a specific example in the code that was never overturned about the change of alimony rules before and after July 1st, 1977.
Mr. Hatfield.
Mr. Chairman, if I may briefly respond to that, and I think I said this yesterday on the meeting, that look at the reasons why we're being asked to do this, and I don't contribute any improper motive to Representative Crawford in the way I offer an amendment, but the reasons he's telling us that we need to do this are because that people have factored in property settlements or trade-offs of property and trade-offs that are made with regard to child support. Those submit to you have done that improperly, because child support and property settlements should be two different things. And they have already shown a willingness to trade off against their child's entitlement to support in order that they get more alimony, that they get more property division. They've shown a willingness to trade off their child's entitlement to support in order to get something for themselves. Now, why should we give those people a break by passing this amendment?
Mr. Chairman, can I respond?
Mr. Crawford, yes, sir.
I'm afraid the judges did the same thing, Representative Hatfield. It's not just people that agreed. I've seen judges that have traded off. They've traded off all sorts of stuff in an order against child support, where they would deviate from the guidelines and say, because of this, this, and this, child support's going to be set at this. You've had deviations all the time, not just by parties, but by the judge.
All right, any further discussion before the chair jumps in? Okay, Ms. Travis?
And just for purposes of clarification and full disclosure, I wanted you also to know that this amendment, in addition to what Representative Crawford has said, also works in the language that Representative Lindsay was proposing, having to do with the 15% and the 30%.
Yeah, that's true.
If you went to trial, it's 15% issue and 30% if it was a settlement agreement. That's
You're talking about the amendment?
No,
Oh,
sir,
549.
it's in this amendment.
Oh, it's in it,
already
okay.
worked in.
It's worked in. It's incorporated. I'm sorry, Mr. Chairman, I didn't mean nothing. You're right. Thank you.
All right, let me state what I understand the current day law is dealing with the modification of child support, and that is you could have a decree entered today by a court, whether it be by consent agreement or by court-ordered judgment. A party could come back the next day and file a modification because the law says the 2-year limitation of modification only applies for the time of entering a final order of a modification judgment. So effectively, somebody out there who has, let's say, an existing order, where there has been nothing done as far as any prior changes, has a right to seek, whatever we do, has a right to seek tomorrow, once this bill becomes enacted, a modification. Now, had they sought one 2 years ago, they would still have the same right. We're not going to do anything as far as addressing the changes of that body of law. The thing that's worried the chair, as far as talking about this subject for so long, is the issue we've had go around about where the parties have entered into agreements, and those agreements became a judgment of the court where there has been a weighing of benefits by either taking property or reducing property, increasing or reducing child support, and the court is not going to be cognizant of those changes just by reason of the fact we can't tell. It's not in the agreement per se, unless it's spelled out that way, and rarely do I ever see an agreement spell it out. I want you to be aware that we do have an amendment. I wanted to talk about yours first, Mr. Crawford, so we can have a chance to look at that. That's why I took a little time studying my sheet here. You have another amendment, which is 290549T, which is being presented, assuming your amendment were not to pass. That is this one. And what it does, it recognizes the 1530 situation, but it goes also to recognize the fact that if there is an order that has been entered based upon only a contested trial, the order is based upon a contested trial, but if there's been an agreement, then there's got to be a larger percentage differential.
That's in this amendment also.
But I do have some concerns, chair-wise does, what was also raised, questioning what we may be going into as far as this application. I think we're accomplishing what we need to do under here without all the additional provisions about cutoff and start times, depending on when the order was entered. That's just my chair's reflection on it. Any further discussion? If you want to take time to look at it.
Mr. Chairman, can I ask a question?
Yes, sir, Mr. Fleming.
Trying to understand where we are here now. The point that I understood Mr. Crawford was making, that I'm sympathetic with, I just have questions about the constitutionality, was about this not being retroactive to any modifications of settlements that are taking place now. But on line 26 on page 1, and yours is 0551. On
Is it?
Right.
Yes, that's right.
It is 551.
Line 26 talks about the 30%. That's a pretty big change from the vote we just had on Mr. Tumlin or Mr. Lindsay's issue, isn't it? Am I confused on that?
Yeah, that's a different issue.
These are exactly the same.
Okay.
It's,
My bad.
Yeah, I think it's just definition. I think you're right.
Any further discussion? We have before us the Crawford Amendment 0551. We're ready to vote. All in favor of the amendment, and we are amending it to lines 30 through 36 of page 26 and lines 1 through 32 of page 27 of Bill 2402S.
And Mr. Chairman, also on line 30, look on page 2 if you don't mind, Mr. Chairman, line 31. There's two amendments
That's
in
correct.
this one.
Sorry. And striking lines 20 and 21 of page 46 and insert the
Yes.
following, which is lines 32 through 35. All in favor of the amendment as stated, raise your right hand. 1, 2, 3, 4, 5, 6, 7. Make it number go. 1, 2. Keep your hands up for get through around there. 1, 2, 3, 4, 5, 6, 7, 8. All opposed, like sign. 1, 2, 3, 4. 4 opposed. The motion carries. Chair will entertain a motion for reconsideration. Then, all in favor of the motion, reconsidering the amendment as approved, the Crawford Amendment, raise your right hand in favor of the motion to reconsider. 1, 2, 3, 4. Please hold them up if I get them all counted. 1, 2, 3, 4. All opposed, like sign. 1, 2, 3, 4, 5, 6, 7, 8. The motion fails. The amendment is 0551 as adopted. I need to take a few minutes recess back in to present the bill, or you want to proceed with my absence? Please, let's wait on you.
Actually, Mr. Chairman, I'd rather wait on you guys. We're having a break until we get the bill too.
Let's take about a 10-minute break, please. I'm sorry to do so, but we'll be back. Let's make it 3:30. Everybody report back at 3:30. 3:30. They were? Okay.
I tell you what, we can't help but shoot ourselves in the foot.
I can't well think you saw a lot of these. That was like this.
I was kind of like, you know, constitutional law, that's not that stuff. Yeah. Speaking of catfish.
Got through that.
I was thinking about it. I'm just thinking that when I tried to work with the Civil War Commission, and they were,
If I was already
they
born,
weren't very well, so.
it's going to, council discussed in the bathroom. You can ignore all the stuff. But you're not going to go back and look at division of mayor or assets. You're not going to go back and look at Eleanor. You can look at just that in the vacuum and see which is in the, which is in the
In some
favor.
cases, that's what persuaded me. The ladies that testified yesterday were persuaded me the unfair can be inherent.
I mean,
See, I deal with divorce attorneys.
Let's
Go ask me my
I mean,
opinion.
the report showed, I don't know if it was
That,
actually,
you don't like her.
that's more, I'll talk to you about
She
that.
got, sound like she got two more things. He said, "Earl, will you compromise?" We had a good heart.
Go to Ashford Dunwoody Road.
Well, you got to take 285 east first.
285 east to Ashford. The next exit over is Ashford Dunwoody Road. Go north, and just as you're passing the mall there on the right, you'll see Eatsy's. Pull into that parking lot and circle around to the right. It's right there on the back, kind of the back left or right hand side of the building. Okay. Okay. I didn't know about that, but I'll find it.
They first gave us the 3 days, which is blah blah the 15th and then the day.
Okay.
And then on the back day, we picked them on the umbrella. And so they put the direction on the umbrella.
Okay.
I'm gonna say what I find I say a lot. Diane has that information. And Diane knows exactly what you need. She's a nonsense. Yeah, they're mean too.
Sunset. How you gonna sunset 160 employees?
Yeah.
Duh.
I'm gonna take that. That's right.
Everything happens to come. Yeah. Gotta get out of here.
Yeah, you have to. Maybe it's so technical about it. I'm just kidding. Just trying to pass over the ball.
Let me know how you go. All walls are Thank you, Roger. Glad you're here. First time we've had people in my committee one time in a row. Oh, put you on shackles over there.
That's about it. Everybody's just standing now. That was the whole committee. Yes, sir. I think it's the room. I think people just wanted to see the room. Yeah. Have a more cozy table.
We're still doing the other bill? Yes, yes.
That's a quick one.
That is a quick one. proceed again on the discussion of the Senate Bill 382 is on. We are ready now. I think we've had the previous amendment adopted. We're ready for any further amendments. Ms. Oliver.
I think we're still working off 2402, is that correct?
Correct.
On page 46, section 8, based on the discussion we had yesterday relative to the 50% of the population that's representing themselves right now in court in these matters, the unrepresented pro se litigants, based on the impact that this bill is going to have on the day-to-day operations of the tens of thousands of people coming into the courthouse, of course not having sat at this table and not having participated in any commission and not having the benefit of a lawyer or any background information. We know that the courts, the judges, staffs, clerks, are going to have to do some extra management around the pro se litigants. Extra resources, extra attention, perhaps similar to the Fulton County Family Law Information Center, where they have resources for their 50% of the pro se litigants. I know that there's a lot of work and discussion going on about how the counties are going to absorb this new job, and I think that it's very responsible for us to give them at least an extra 6 months' time before this is implemented. And so I'm offering an amendment that on line 20 and 21 on page 46, that the act shall become effective January 1st, 2007, and I'm aware, based on the last amendment that we passed about the modifications, that my amendment should properly be extended to the dates that were set forth in the last amendment. About those dates, I believe in the last amendment, were June 30th, 06 and July 1st, 06, and those should be changed to December 30th, 06 and January 1st, 07.
Speaking of the existing law.
Yes, sir. The purpose of my amendment is to delay implementation for 6 months to aid the counties with the pro se litigants.
All right. Discussion. Anybody have a matter of discussion? Let me ask Ms. Travis, do we need to have something prepared in writing because of what we're doing with that previous law that was rescinded based upon the enactment of this law, which says it will be rescinded effective as of, the date was now June 30th.
If that amendment's passed, the current version, which is House Bill 221, would be in effect from July 1, 2006 through December 31st, 2006, and then this new bill would take effect.
So I need to clarify my amendment, make an amendment that I don't know what section of 221, how it's codified today, that would change that from July 1st, 06 to January.
Why don't we state it as an intent? We want to state it as an intent.
It is my intent to delay the...
Let me ask Ms. Travis something first. Excuse me. How would you want it done, Ms. Travis? I want you to be comfortable with what you're looking at as a potential amendment to this bill.
Well, House Bill 221 went into a number of different code sections and changed things, and some of it, without having it in front of me, I can't tell you all the delayed effective dates. Some of it is...
we had step things. I remember several things happening.
Well, some took effect immediately and some was delayed. So I'd have to have 221 before me to be able to figure that out. And then in addition to that, the committee would need to decide what's the law going to be in that 6-month period. Is it going to be 221 as it is on the books, so to speak, or is it going to be prior law? And if it's going to be prior law, then we'd have to enact that in this bill.
Okay. I'm afraid I'm going to have to call the proposed motion out of order for a reason that we're not able to, with clarity, know what we're dealing with at the moment. I'm not trying to kill your idea. I'm just saying I have some concerns trying to pass something without having the appropriate language for us.
I'm understanding of that, Mr. Chairman, but given the fact that this bill is very likely to become structured very soon, and any of my input or ideas is not going to be available for discussion at any other point,
I'm going to do this. I'm going to give you a chance. I'm going to give every committee member an opportunity to present whatever they want. And you can, in a few minutes, we're going to take a recess, let you go with Ms. Travis upstairs and look at it. If you can appropriately word something and come back to the committee, we'll consider it. Because we have a bill that we need to also consider that's not involved with this, but we'll do that in your absence, if that's all right. Do you understand?
yes, sir.
I'll give that
I
opportunity.
just don't know. Ms. Travis isn't going to be available, though. I mean, I'm aware.
She will be excused to go with you.
Can we do that in 10 minutes?
Well,
You just go to the clerk's office and give us the document.
2:21.
2:21.
All right, we'll give you that opportunity.
Okay.
That's what I'm trying to say is I'm not going to close the door on you. I want to have every chance to present what your wishes are to the committee for their consideration. The next thing we're going to consider is I have the last amendment, I believe, that we're going to talk about, which is I gave it to you, didn't I? We're going to consider a amendment that was also prepared partly by me, but I'm going to ask Mr. Fleming, as I'm chairing the committee, to present the amendment to you. Mr. Fleming.
And I think it's not a stretch to say that this deals with the direct appeals. And I know that the Speaker asked me to, the Chairman, to bring this amendment to you to not allow the direct appeals. And I think Chief Justice Shears also, and the rest of the court appeals, the Supreme Court would be very happy with us if we did this. So the amendment is AM 290547. I know there's been a great deal of discussion about this in the committee before, Mr. Chairman. And so I think most members understand what we're trying to do here.
Yes. Let me, if I might, embellish upon the comments. There's a couple of things I want to point out. As was stated by Ms. Nesbitt yesterday before the committee, and I was on the committee back at the time when we were raising the concerns with the Supreme Court. In fact, we had Justice Fletcher come in to address us. And there was a growing concern that we were not seeing appeals being accepted on discretionary appeals by the Supreme Court dealing with either the child support questions or the divorce and equitable division of property. And I know my own personal concern was that we had a number of things that were brought about by, I'll say, judicial decree dealing with the enlargement of the area of domestic relation law, family law, as of, for instance, the equitable division of property was something that was not ever enacted by statute, but was done so by the Supreme Court issuing a decree on it. Now, with that said, we felt there was not additional steps being taken to clarify what were ongoing issues and questions dealing with how that would be handled, among other things. When you had, for instance, a property which was maybe brought into marriage and grew in values, open to issues that had to be resolved from time to time through the litigation, closely held business, parties were involved with them part of the time. The parties did not jointly have the involvement of the business. So we always were trying to face and clear these up. The ones of you who deal with this know that better than I. I quit dealing with divorce law several years ago because of the emotional side of it. I couldn't take it. But the Supreme Court did tell us that we were going to set up a pilot program which has been ongoing. And to their credit, they are accepting what is informed information we've received, saying that they are now taking all of these except where they find it to be truly what they consider a frivolous appeal or something that doesn't need to be addressed by the appellate courts. So I'm comfortable with that side of it. I feel that they've done a decent job, and they express they're going to continue doing that, and we're going to continue monitoring that issue in the future. The other part of it is, I'm afraid that what we leave open here is something that can be used perhaps in the litigation as a leverage for one side or the other. And to point out, if you don't go through the discretionary, as Ms. Nesbitt mentioned, you're talking about up to 2 years before you finally get a decision. At least with the discretionary appeal, you should have an answer within 60 days, knowing whether it's going to be accepted or not. One of the reasons we put this provision in here last year, if the committee remembers, we were doing away with a lot of what we felt were the jury questions. So there would not be a jury trial dealing with the areas of child support. But we've modified that under 382. The bill that came in to the Senate and remains before you allows for the jury trial not only on the issue of determining what is gross income, but also these deviations that may be applied. It's not up to the court anymore. It would be a full jury issue, in other words, looking at that part, which the jury makes a resolution if you want a jury trial, and then the court will apply those findings to the tables to determine what will be the child support. With that said, bringing the argument to close, I think we're in an appropriate place to say this is an expense that we're putting in there that doesn't need to be there. Now, it's an expense on the parties and delay times, as well as the leveraging that may go on between parties, but also the expense to the court and effectively having to accept something which is not going to be in the best interest of public policy of the state. Any comments or thoughts anyone wishes to make? Ms. Oliver.
The only comment I'd like to make is that I want to make sure that the Supreme Court is required to rule on all the different legal issues that are going to arise from this particular bill.
And I can't speak for the Supreme Court. I can suggest what they tell us is they are going to, as they are doing now with the appropriate appeals that are coming before them. Any further thoughts or comments? All ready to consider the motion. The motion is, as stated by Mr. Fleming, to accept the amendment identified as AM 290547. All in favor of the amendment? Yes, sir. Excuse me, Mr. Tomlin.
One clerical amendment.
Yes, sir.
Line 27, delete the colon and put in a period of quotation.
That's on line 28.
Yeah.
We didn't delete that.
With the quotation, see.
Line 28 at the very end has a period and a quotation. That'll follow back to 27.
Okay, it just
And
takes
then-
care of it.
Yeah.
I thought it.
And you have the striking of the semicolon of the line through it there. He is away. All in favor of the amendment as stated signify by saying aye. Aye. Opposed, like sign.
No.
We have one opposition. I think the ayes have it. The motion carries. That is all. Is there any other amendment?
Yes, sir.
You have your amendment?
Yes, sir.
All right, let's hear what your amendment is,
Ms.
Oliver.
Travis is going to help me. On 2402S, on page 46, line 20 and 21, I asked that July 1st, 06 be replaced with January 1st, 07 in those two places. On Mr.
Let's locate that if I might, please. I'm sorry.
Page 46,
46.
line 20 and 21.
Okay.
This is the overall bill delay
Right.
effective date to July 07 first. And then working from...
Wait, July or you say January?
I apologize. January 1st, 07.
All right.
And then working from Mr. Crawford's amendment that passed, 0551, I believe I'm correct about that, on page 2 of his amendment, line 32, July 1st, 07, instead of January 1st, 07 instead of July 1st, 06.
That's on line 3?
On 32.
Line
Page
30,
2.
excuse me. Okay.
And let me back up, right. On line 3, on page 2, July 1st, 06 shall be replaced with December 31st, 06. Then line 32, July 1st shall be replaced with January 1st, 07. On line 33, July 1st shall be replaced with January 1st, 07. And June 30th, 06 shall be replaced with December 31st, 06. And December 31st, 06 on line 34. And June 30th, 06 on line 35 replaced with December 31st, 06. Now, further, looking at House Bill 221, which is Title 19.7.2, excuse me, I ask that the effective date, which is set forth in that statute, 19.7.2, of July 1st, 06, be changed to January 1st, 07.
What we really have to do, if you wanted to do that, is we'd have to divide this bill up into two parts. One part would be basically what's in 2402 as you have it, and that would have the effective dates as you propose. And then part one of the bill would have to be restating the law as it currently is. In other words, go back to the unstricken portions of all of House Bill 221, except for Section 11 of the bill, which has already become effective, and that has to do with the commission. So you'd have to restate all the prior law.
Ms.
Do you understand what I'm saying?
Go back to what you said, please, Ms. Travis.
Because what 221 did is, like if you look in your code book, if you look in the hardbound version of it, you'll have the existing law. In the supplement, it says this takes effect, this is a delayed effective date, this takes effect July 1, 2006. The Senate Bill 382 is going to change what you would see in your supplement. But if you want to delay it for another 6 months, you're going to have to put into the code what's essentially have been taken out to cover that 6-month period. So what we would have to reinstate, because it's being repealed, effective July 1, 2006, is, for example, the code, well, Title 5, that's a little bit controversial because what you've done. Title 7, that's also been changed. But all of the stuff in Title 19 would have to be the existing code language, the book language, which I could do.
Ms. Oliver?
But that's how it would be done, Part 1 and Part 2 of the bill.
I'm a rule we have to have a published amendment to look at this. I'm sorry. I'm fearful that what we're traveling on right now may be a problem in trying to say we're going to extend the time. The second thing I want to say about it is I have been concerned as you're raising this issue. I have spoken with those people who are eminently involved with getting this thing prepared for the July 1, specifically Judge Abbott. I see her as being, I call the trainer to go out and get everybody ready. They've got seminars set up in April, several of them. She assures me that everything is going in place, even through DHR, to have it prepared to start July 1. And I would have to say to consider your amendment, Chair, that would have to be a published amendment. That's why we went over these yesterday talking about it.
I understand that, Mr. Chairman. I accept that really. I don't think we're going to be ready July 1st, but
it may be a train wreck, but we'll have to travel on that basis at the moment, unless somebody gives us the word otherwise. Any further amendments? Please, Ms. Travis, let you state your amendment.
In your package, you have a copy of Code Section 19-6-26, and if you go to subsection A4, this talks about modification with respect to alimony and child support generally.
Right.
And I believe, and I talked to Bill Radley before with the commission, and I think we need to add the word Georgia in paragraph 4 under modification, a Georgia child support order. So modification would read, modification means a change in a Georgia child support order that affects the amount, scope, or duration of the order and modifies, replaces, supersedes, or otherwise is made subsequent to a Georgia child support order or a foreign child support order.
Yeah, 2 times we're replacing the word Georgia, or putting place in the word Georgia in paragraph 4.
Right.
Each time before the child support phrase.
Right, and that would be a new section of the bill.
Okay.
That's an oversight.
Does that lie true also with the paragraphs 5 and 6 where child support is only in that area? I don't know. moving party means the party initiating an action for the modification of a Georgia child support order. And it says also or foreign child support orders. It may not be necessary because both of them we use child support order or foreign child support order.
I think everywhere it's saying child support. I think it's
All right.
Could we restate why that is?
We're going to find out. Let me get Ms. Travis to guide us on this point.
Yeah, that's what I'm just looking at.
Order of a Georgia court or order of a Georgia court.
That would be probably the easier way to do it, Representative Lane. If we just, instead of changing it throughout, if we just said child support order in paragraph 1 means a judgment, decree, or order of a Georgia court or authorized administrative agency.
Why don't you step up until we can all hear you? Step up, stand up for me, please.
Subsection K as was. I mean, I don't know if the new amendment has that much effect, but it was talking about prior award and the
Right.
current guidelines. We want to make sure that that's the Georgia prior award and not like Indiana prior award from other states. You're doing that 15% or 30% vary. Talk about from the Georgia.
Okay.
That's what that really
Okay.
What's her name?
This is Ms. Radley.
Just so I can, validate the word on that.
State your name for
Okay,
the
I'm
benefit.
sorry. I'm Jill Radwin, and I serve as the staff attorney with the Child Support Commission.
Gotcha. Okay.
And if it, Jill Travis brought this up, because this section deals with domesticating a child support order from another state.
All right. Let me state the amendment then we're talking about. If I understand it, Ms. Travis, is on your sheet that you handed out. 19926A, paragraph 1. We're inserting Georgia before the word court on that first line.
And that's it.
And that's the only change we made. Correct? Did everyone understand the amendment? Just to clarify the type of orders we're referencing for a child support order in the law. Any further discussion on the amendment? All in favor of the amendment signify by saying aye. Opposed, like sign. The amendment carries. We're now back to the main question, which is and I frankly suggest we don't have a main question. Do I have a motion of due pass as to 292402S as amended, as a committee substitute? It's been moved. Any discussion on the motion? All in favor of the motion signify by saying aye. Opposed, like sign.
No.
Let's have a show of hands. We'll have a show of hands on the motion. All in favor of the motion as stated, raise your right hand. 1, 2, 3, 4, 5, 6, 7. Those opposed, like sign. 1, 2, 3, 4, 5. The motion carries 7-5.
You're opposed.
Motion do pass. Substitute. We have one other bill right quick. Let me bring to your attention. In your file, you have a bill, Senate Bill 419. The purpose of this bill, this is another bill by Senator Hart as a sponsor, prime sponsor. This is to allow, under the law, when a person receives a payment through the lottery of prizes of $2,500 and more, and there is an outstanding child support order through the Child Support Enforcement Agency of Department of Human Resources, DHR, that they may have a means of attaching those funds for the reason of payment toward the delinquent child support. Ms. Radley, would you like to say something about it?
Actually, I was not involved in that.
Say nothing then. Is there anybody here who would like to speak to it? Anybody wish to speak in favor or in opposition from the public? Do we have discussion? Then it's in the breast of the committee. Do we have discussion among the committee?
Mr. Chairman.
Please, Mr. Bruce. Well, we had this on the calendar yesterday, but I didn't consider it. I'm sorry I misstated that. It was already on the calendar that we published and had both bills on them, and I just neglected to recognize that we had a continuing another bill to be considered, and I apologize, Mr. Bruce. Any further discussion, Mr. Clay?
As a policy matter, Mr. Chairman, why wouldn't the claim for delinquent child support apply to all prizes? Do I read that to mean that you take your first $2,500 of lottery winnings free and clear of your delinquent child support?
I think it's only if the award is of an amount of $2,500 or more. In other words, if you receive $5,000, it does not mean only $2,500. But if the award itself is $2,500 or more, then the claim be against all the award. If the award is less than $2,500, it would not be, because there'd be so many. I think the concern there is trying to keep track of it. Ms. Rabin could do that, I'm sure. Any further discussions on the motion? Do I have not motion on the bill? Excuse me, on Senate Bill 419. The chair will entertain a motion.
Move to pass.
The move to pass. Any discussion on the motion? You ready to vote on the motion? All in favor of the motion signify by saying aye. Aye. Opposed, like sign. Ayes have it. It is passed as presented to us.
Mr. Chairman,
Yes,
wish to file a minority report in
Sure.
relation to passage of 382. Would you remind me? I believe I have until.
I think it's until it comes out of rules, if I recall. Is that, what's the word on that, Ms. Fleming? You remember the... When I report, when I send the bill up?
So in other words, by
Okay.
10 o'clock.
Okay, yeah.
Okay.
By tomorrow morning, if you would, please have that to
By
my
9
office.
o'clock?
I'll give you till 10 o'clock. Can't be on the calendar tomorrow anyway. Thank you. Anything further to come before the committee? I appreciate very much. This may be the last time that we'll be together this year, and I'm so grateful to have the chance to serve with all.
Tonight.
Oh, I got dinner. I thought it was a committee meeting.
Oh, okay.
I wrote,
on Thursday.
excuse me. What I'm saying. Back up.
Try to get rid of
I'm old. I'm old. I tried.
Wishful thinking.
I'm old and forgetful. Okay, we'll meet then Thursday. Then I'll make my Washington speech. Farewell to troops. Thank you.